Well, my name's Gene Vaught. I'm one of your lawyers at the beach, and we're here again today, this afternoon, with one of my law partners and good friends for a long time, Mr. Scott Hucks. And we get together from time to time, and we talk about basic issues in the law. Scott practices primarily criminal law, and I'm on the civil side, but have done some criminal as well. And always good to get together and talk. And you know, one of the things, Scott, that's really been prominent out there in the news for a long time, but especially for the past month or so, is this trial of Alec Murdaugh that's going on down in Walterboro in the lower part of the state. And I think pretty much everywhere I go, every place I go into, every person I talk to seems to want to talk about that.
Absolutely. It seems like it's the only thing on anybody's mind right now in South Carolina. We were talking about before we started filming that our wives are both
big time
adamantly, following every hair's breadth that's going on in
right.
the thing. And it's an interesting trial because I don't know about you. You've been practicing law longer than me, but I've tried a number of cases in this circuit particularly, but other places in the state, and I have never seen a case so long. I remember judges when I first became a lawyer get in the trial, and the judge would say, "You got till Wednesday, and this thing's over with, right? It's time to do this." Judicial economy, as you're aware, you've heard
Correct.
that phrase a million times, and if folks want to know what it means, it really means efficiency. Judicial economy, efficient use of the judicial system.
Right.
The judge's time, the jury's time, the courtroom's time. Because think about it, when you go to trial, you got a judge, you have a clerk, the judge has a clerk, you have a clerk of court, you have a court reporter, you have at least one prosecutor, or in this case, a team of prosecutors, you have an entire defense team, you have the clerk of court staff, sometimes a dozen people working on this case, taking care of jurors, vetting jurors. In this case, the jury selection took days and days and days. Right. And the scale of it is something that I've not seen before, even on death penalty cases that I've had the ability to be around and help with as an attorney. And I don't know, have you ever seen anything remotely?
Not here. And again, I guess the unique thing for us is that it's happening right here in our backyard. This is not the O.J. Simpson trial in California for many, many years ago that went on for some period of time, or the Johnny Depp trial. This is happening literally right down the road in the South Carolina Low Country.
And if you remember, like the O.J. Simpson trial, I don't believe, I was in high school when it happened, but I don't remember it going on all day.
No,
it went on for a certain window of each day.
Correct.
And then they'd come back whenever they were scheduled to come back. But in South Carolina, as you're aware, when your trial starts, your trial goes till it's done. Right?
Correct.
It goes till it's over, till the jury's back with a verdict, or there's a mistrial, or something ends the prosecution of that case at that time. And for this one to go on so long, at least in my experience, has been a real exception to any rule that I've ever.
Absolutely. And it's, as we sit here today, it's still going on, and who knows, I mean, it could go on another 2 or 3 days, could go on another 2 or 3 weeks. And I want to get into some of the specifics of that trial. Again, unless you just crawled out from under a rock yesterday, or you've been on a deserted island for the past month or so and have no clue, Alec Murdaugh was an attorney, a very prominent, thought to be well-respected at one time attorney in the Low Country, the Hampton area of South Carolina. He was a member of a firm which has been in existence for 100 years.
Long time.
It started by his great-granddaddy, and then his granddaddy, and then his daddy, and so on and so forth, all of whom, through the history of South Carolina lawyers, especially in the Low Country, were very prominent, well-respected attorneys.
Absolutely, yes, and including Mr. Murdaugh, from my knowledge of him, of course, because all the rest of those guys weren't practicing law.
Right.
I've been practicing law, but everything I ever heard about him were that they, that part of the state has a reputation for giving out large jury verdicts on civil
Correct.
cases.
Absolutely.
And
unlike us here in Horry County.
Yeah, not as common here for sure. That they're in a spot that's famous for giving out in the state for giving out large
Correct.
civil jury verdicts, and that they were kind of the top of the heap of folks who did that. That was their reputation.
right.
Whether they were or not, I can't vouch for, but that was the reputation that we had heard through the bar and going to conventions and going to things. I know that I'd heard that
Right.
about that firm myself over the years.
Well, absolutely. And again, you know, we could sit here and talk to Christmas about the story and the background information. And I
I
mean,
bet folks want to hear about the issues, though.
Oh, they do. But essentially, you know, what Alex Murdaugh was accused and stands trial currently for the murder of his wife, Maggie, and his youngest son, Paul. And that is what this trial is about, or supposed to be about. Those are the charges, the only charges he's facing at this time. Now, there's a lot of other bad stuff out there. He has been charged with some 95 to 100 financial crimes where he was stealing money from clients and his law firm, former law firm.
I think the allegation's at least $10 million.
At least.
At
And I
least
think
$10
the number
million.
keeps going up. And so certainly that is a trial that's still yet to come. There's this allegation of the faked or staged drive-by shooting, the attempt to take his life, which turned out to be false. And then, of course, the tragic case that kind of was back before this involving his son allegedly driving a boat that was wrecked, and a young lady, Mallory Beach, was tragically killed in that accident. So all that is kind of the backdrop of this case. But again, this case is about him being charged with the murder of his wife and his son. One other thing that I wanted to point out and kind of get you to generally comment on before we start getting to some of the issues is you have a very unique perspective when it comes to criminal law.
My wife would tell you I have a unique perspective on all kinds of stuff.
that you're wrong and she's right. I got that. I understand. But I've known, like I said, we've known each other for a long time. And when we first met many years ago, you worked with the solicitor's office and were a prosecutor.
Yes. I was a prosecutor. Not necessarily a prosecutor the whole time, but I always wanted to be a courtroom lawyer.
Right.
That's what I wanted to be. And,
Right.
And I have a very short attention span by nature. And because of that, criminal law really jumped out at me because I had the ability to work on multiple things at a time, had the ability to compartmentalize cases, figure them out, get the facts together. There's always something new in criminal law. With a lot of the personal injury stuff that you do and that we've done together over the years, you see a lot of times you have a head-on collision, you have a rear-end collision, you have a T-bone collision, you have a set number of things that happen. And while the facts of each case are materially different, a lot of it is wound into a window. And I found that while I really enjoyed that because I got to help people with it, the criminal law was a thing that interested me because it seemed to me to be so vast and every crime has elements and every trial has sections and every part of a trial has rules, and learning to experiment and work within them really became a passion of mine. And you and I coached mock trial together for a number of years. And learning how to work within the rules of court was something that really, really interested me as a person that wanted to be a trial lawyer. And I've had some, I like, knock on wood, reasonable success at it. And I still to this day really enjoy the courtroom part of being a lawyer, probably more than any other part of it. And you were talking about just a moment ago, all of the different floating around charges that are out there for Mr. Murdaugh. I think he calls himself Murdoch. I heard it today, but I'm not sure how they pronounce it down there.
In the low state.
I'm from Myrtle Beach. You know, I pronounce it like I'm from Myrtle Beach. And I mentioned it earlier about judicial economy.
Right.
And it's one of the things that jumps out to me about this case just in general, prior to talking about the rules or any rulings or evidentiary decisions that a judge made. What jumps out at me is it seems like they have the state, through the state attorney general's office, has an extremely tight case against him for stealing a whole bunch of money.
You would think so.
And any person that steals money in South Carolina is called larceny.
Right.
And if you utilize a bank to do it, it's bank fraud.
Right.
So if you have a bank fraud or a larceny, we'll start with larceny. Any larceny over $10,000 in under South Carolina law carries 10 years in prison.
And he had 95.
So he had a pile of them. Yeah.
Counts of that.
So those are generally paperwork-driven cases.
Right.
And if you've watched any of this trial, you see that they've gotten into a whole lot of those details. The judge has allowed the prosecution to get into that. And we can talk about why and how,
We will,
and whether we
will,
think
yeah.
it's a good idea or not.
Right.
A little further down. But all of the rules of evidence in court in South Carolina start off with this theory of judicial economy. Don't make a courtroom a circus. Do what you do in the most efficient manner possible, because there's a lot of people spending time and money and jurors. Everybody's there on point. The idea of judicial economy is come in here as efficiently as possible and get your job done. And it seems to me, just as an outside observer who understands a whole lot of stuff about criminal law, that if he's got, for the sake of argument, let's say he only has 10 counts of stealing that they believe they can prove. Any of those cases could be tried in 3 to 5 days. Pick a jury all the way to the jury coming back with a verdict. And they seem to be quite strong cases. And if they loaded him up with 10 of those and they gave him 100 years in prison, to me that would seem like the appropriate judicial economy.
Exactly.
So the appropriate use of judicial economy. And then the Attorney General would not be sitting here bringing up evidence at the very last minute. They brought out cell phone evidence in the middle of trial.
Right.
So they're in the midst of a trial, state presenting its case, and show up with a lot of evidence. Many judges would not have allowed that evidence in.
Right.
As a violation of Rule 5 or Brady, which are our discovery rules, not being turned over in time to be fully vetted. But I believe it was OnStar. Maybe it wasn't cell phone. Maybe it was vehicle, GPS, something like that. But it would give the state so much time, because we don't have a statute of limitations on criminal activity in South Carolina. The state would have had the next however many years they needed to put together an airtight case. And I think that you see that rush to get to court in the way that this case has gone. If you watch it on, well, we watch it on YouTube because we don't have cable at home because we cut the cord a number of years ago. But if you watch it, to me, it seems like a whole lot of it's rushed and a whole lot of it's thrown together. And I think part of that is because the defense in the case, Mr. Harpootlian, has had the ability to push for a speedy trial. And you don't have to push, you don't get the opportunity to push for that speedy trial and have a judge hanging over the prosecutor's head saying, when are you going to try your case? When are you going to try your case? Particularly with the vast sums of money and time that the state has put into this. How many experts have they put up?
Right.
And some of it's science that I don't particularly like, but they've put up so many paid people. How many tens or hundreds of thousands of dollars, or millions of dollars have they spent in moving this case forward against Mr. Murdaugh? And that's without making a judgment on my behalf about whether he did it or not. That's irrelevant to this particular conversation in my book. And but when you look at all of the vast resources they're spending, you have to really ask yourself, are they doing this just because they want to be on TV and try a case that's popular in the news? Or are they so vested in this case that, from my perspective, has a weaker evidence than all these financial crimes? They could put him in jail for 100 years, try and potentially put him in jail for 100 years, and have 100 years to put their case together and make it as airtight as they wanted. And you have to ask yourself about the motivations of everybody involved there.
And that's a good point. And let me ask you, because you have been a prosecutor. You were a prosecutor for many years. You prosecuted every type of crime out there. And then you took off that hat and you moved into private practice, and now your practice is almost exclusively, criminal defense.
Right.
That's a different hat to put on. So you were making decisions. We're all making decisions, but on strategic basis as a prosecutor, as the state, how you want to present a case, if you want to present a case, what someone should be charged with, and of course how you put your case together. And then on the other side, as a criminal defense attorney, you're doing the same thing. You're preparing your case. You're looking at the evidence. You're deciding what your defense is going to be, or your defenses are going to be. And there's so many different elements to that. Who are you going to call as a witness? Who are you not going to call as a witness? What are you going to object? What are you not going to object to? And the first thing I really wanted to get into talking about this case, because like I said, we go home, we talk with our wives about it. I go get my hair cut yesterday.
Yep.
Guys in the barber shop are sitting around talking about it. I walk in the store afterwards. The clerk there, who I know, says, and knows I'm a lawyer. Oh, let me ask you this about the Murdaugh case. But a lot of people that aren't lawyers, we hear these terms every day. They're general terms to us. But to people who are not lawyers, who are maybe for the first time mesmerized and really focusing on a trial, a big time trial, you hear terms and people don't really know what they mean. And two terms I want to start with today that we've heard a lot in this case is direct evidence versus circumstantial evidence. Direct evidence, you hear the defense hammering on the fact that the state's case is purely based on circumstantial evidence, lack of direct evidence. Before we get into specifics from this trial, kind of give people an understanding, a basic definition. What is direct evidence? What is circumstantial evidence? Is one better than the other? Does one have more weight?
So it's a really good question. And I remember when I first became a courtroom lawyer, a trial lawyer, that I wrestled with it a lot, trying to figure out, as a young prosecutor, when I was a prosecutor, in circumstantial and direct evidence it's a clear and distinct difference, right? A direct evidence is, I've got a picture of you doing something.
Okay.
Or I have a witness who saw you do something. Those are direct evidence that you did it.
I'm holding the gun.
Yeah, I opened the window and I saw it raining.
Okay.
That means it was raining. I witnessed it raining, right? Circumstantial evidence is a lack of actual direct evidence that would lead people to believe something.
Okay.
So I get up in the morning and I walk outside and there's mud puddles all over my driveway and the sprinklers aren't on. That's circumstantial evidence it rained last night.
Okay.
So circumstances would dictate that something happened.
Okay.
In this particular case, I think one of the circumstantial things that the state has really, really harped on is this .300 blackout rifle. There's a rifle. They say that Mr. Murdaugh owned 3 of these over the course of a number of years in a .300 blackout caliber, which just happens to be the same caliber that killed his wife or son, one of them, killed one of the victims. And as the weapon that killed one of the victims is in the same caliber of a weapon that he owned, that's a circumstantial evidence that his gun killed his family member.
Right.
Now, on the flip side of that, .300 blackout is one of the most common pieces of ammunition, bullets, used to kill animals in America over the last number of years. It's got very well renowned for its knockdown power, as well as being able to fit into a standard AR style rifle, which allows it to have high capacity. A lot of people that hunt, particularly hogs, varmints, coyotes, things they don't want on their land that tear up the land or harm livestock. It is a humongously popular caliber because it can hold a lot of bullets that have a lot of knockdown power in that particular layout. What I believe to be another piece of circumstantial evidence that the state has presented as direct evidence, because there could be a thin line there sometimes, is there's been evidence from an expert from SLED, the South Carolina Law Enforcement Division, an expert witness from SLED that said that the brass, when you shoot a weapon, the bullet comes out of the barrel, and then the brass is ejected if it's a semi-automatic weapon.
Right.
So the brass, everybody has seen a piece before, a brass that flies out of the side of the slide of a weapon whenever it's fired. So they brought an expert in that compared the scratches caused by the extractor and feed ramp of a particular rifle on the case. So the casing's made out of brass. As the brass goes in and out of the chamber, there's a claw on the side of the slide or the receiver that as it comes back, it hooks on a rim on the side of the casing and comes back and it flicks it out to the side on that particular type of rifle. The rifle they're alleging was used to kill the family member. So they take a microscope and a magnifying glass, whatever thing they take, they look at it up close and they find some old brass from a shooting range and a flower pot somewhere else on the property. And they put them under a microscope, put them under a magnifying glass, and they say the markings on this piece of old brass that's been here for quite some time, and this brass that was near the bodies, that circumstantially was the brass belonging to the bullet that killed the family member. So you have circumstantial evidence stacked on top of circumstantial evidence in that situation. They have the same markings on them from the claw of an extractor and a feed ramp and barrel. And because of that, they had to be fired from the same weapon. I think there's...
Or at least it creates an impression from which a jury can draw an inference that, well, and just like you said with the rain.
Right, absolutely.
I see the rain. I walk outside. I see it raining. There's a puddle. I know that came from the rain. That's direct evidence. I'm asleep. I get up. I didn't see the rain, but when I walk outside, the ground is wet and there's a puddle there that wasn't there before I went to sleep. Circumstantial evidence, but it is evidence from which that jury, if they choose to believe that, and it's reasonable, can infer that that's what happened.
And the jury charge for that judges in South Carolina give, or at least have on the number of occasions that I've had to utilize them in court on as either a defense lawyer or a prosecutor, says that a jury has the ability to believe one witness against many or many witnesses against one.
Correct.
And they have the ability to believe one piece of evidence against many, or one piece of, or many pieces of evidence against one. And I believe what the state's trying to do circumstantially here is to build a wall, right? To build a wall, even if the bricks are weak, if you build the wall high enough, you get where you're trying to get. And the problem with circumstantial evidence, well, the problem with direct evidence, I guess, to start with, is that somebody could be mistaken. I could see that I saw it raining outside, and I just didn't realize there was a helicopter putting a fire out next door. It's something silly like that.
I got you.
The problem with circumstantial evidence is a deeper problem, because you could have had a pipe busted in your front yard that caused those puddles, and you're assuming it's raining. And the defense, under the United States Constitution, the defendant doesn't have to prove anything. The defendant doesn't have to say a word in his defense. The state has to carry that burden across the finish line, because they're the ones trying to put somebody in prison for a substantial period of time. The Constitution says you cannot be deprived of your life or liberty. And potentially that's what the criminal justice system is trying to do, take away your life and liberty. So the defense doesn't have to prove anything. The ball is completely in the state's court to get it across the line. And circumstantial evidence, according to South Carolina law, is just as good as direct evidence, in that the jury can look at both of them and draw their own determinations as to what they mean. Everybody needs to remember that we're your lawyers at the beach, and we're always here for you. Anything we can ever do for you, give us a call. We got 3 locations around the Grand Strand.